I want to bracket two things, which I deal with in the paper, but I'm not going to detain us with today, but I'm happy to talk about later to dive more into it. But I'm just going to take these for granted for the purposes of this conversation. So the first thing is that it is a fact that in reserves, not too far from where you are all located and all across Canada, public services are almost always quite a bit worse. And I mean schools, I mean fire services, I mean child welfare, which you may have heard about in the news with tribunal and court cases, police, uh, access to drinking water. That's what I'm talking about. So these public services have been worse for a long time. And I give a relatively brief account in the paper of why that is the case. And there's a legal, constitutional story behind that, and there's a political story, and I gesture at that. And as Richard mentioned, Douglas Sanderson, who's at U of T, who is my teacher, we wrote a book that came out a couple years ago that focused on one dimension of this, which was schools. So if you're curious in a kind of narrative historical story about how that happened, I'd be pleased if you took a look there. But for now, I just want you to know it's a fact, and it's quite an ugly fact. And that's part of where the impetus for this work is coming. And the second piece, which we can talk about, but I'm not going to dive into now, is it's a bit curious, or it always seemed curious to me, that despite these large inequalities, our Constitution, through litigation, has not had almost anything to say about this since we got the update in 1982, and I wondered about that for quite some time, and I venture some hypotheses for this, but I want you to know that there's been no case. There's no Brown v. Board of Education for Canada about these unequal services. And I try to give an account of this. And I mention this in part because that's another source of this argument I'm going to present to you. And the thought is, how can we get our Constitution to see this problem, which, up to now, it's been quite silent on. All right. So I'm going to bring you to the main subject of the day. So let's go back to 1982. The Queen and our Prime Minister there were formally incorporating the 1982 Constitution Act, and all of us here today um, know about the Charter of Rights, which is a part of this document. And you may know that there's 34 provisions in this charter. I suspect you spent quite a bit of time, or you will spend quite a bit of time of your law school education on this. You probably also know that right after the charter, there's section 35, which deals with Aboriginal and treaty rights. You may not know about the provision that comes next, which is what I want to focus on today, which is section 36. And I submit to you, and I hope to persuade you, that this provision, which there's never been a substantive ruling on what it means by any court since 1982, is actually quite relevant in thinking about this problem of unequal services on reserves. I suspect it's relevant for other things, but my paper focuses on how I think it's relevant for these unequal services on reserves. And I want to also note to you that the reason, in part, that I'm thinking about this is that there are huge class action cases dealing with unequal services on reserve that are just presently working their way through some federal courts and Court of King's Bench courts in Manitoba, dealing with water and dealing with education and child welfare services. And there's literally many, many tens of billions of dollars of liability that we're talking about by the federal government. And that is why I think this topic is going to be of relevance to federal lawyers and perhaps you as you follow these cases, and perhaps you as you think about how these provisions might be relevant to cases which are that are soon to come. Okay, so I know the text is small on the page. I'm gonna reduce the text in a moment, but I just want to note, as we all know, we're not Americans, so we're not our commitment to originalism is not does not run very deep. Um, and I'm and I mention this because we have to figure out, since a judge has never ruled on this, what does this text mean? Neither, we are not originalists, but we also don't believe in amnesia either. So I want to give you a little bit of a taste of the history of this provision, where it's coming from, because I think it can start the conversation about what it means. And, I'll mention that there were, the negotiations for this specific text, like other parts of the 1982 Constitution Act, it took 13 years to negotiate. There were many, many rounds of negotiations between the provinces and the federal government. And there were 8 drafts of this provision that you're looking at here, which has 2 big parts, 36.1, 36.2. And if you look at what the negotiators had in mind, I think there were 2 main things. And if I drop you down to the second part, 36.2, I'm going to be talking about the equalization clause. And since you're in Alberta, and I was just mentioning to Richard right before we went on live, that this is the most exciting place with Albertans to be speaking about equalization. But the second part of 36 is talking about equalization. And the purpose of this clause was for provinces to secure a commitment by the federal government to be um, sending unconditional transfers to help them deliver public services. And the federal government, you may know that they had started back in the 1950s in making these equalization payments. And in a moment, I'll say a bit more about what equalization is all about. And the provinces wanted, they didn't want it to be a discretionary thing that the federal government could decide to do or to not do. And so they wanted this commitment to this principle written down in the Constitution. The federal government, what they wanted most, and that's what was the origin behind 36.1, was they wanted to secure their spending power to give conditional transfers of money for things like healthcare. So the federal government, as we all know, they're making very large healthcare transfers to all the provinces. They do the same thing for social services. And in exchange, they ask conditions of the provinces. So 36.1, the origins of it in negotiations were the federal government to have a secure constitutional base for them to ask uh, in return for federal spending. And today, you might think that the federal spending power makes this an easy thing for the feds to do, but back in the 1960s and 70s, it was not at all clear that that would be an acceptable way to use federal spending power, and so they wanted some of this language in 36.1. So I want to focus in on a few parts of this text, having said that. And by the way, if anyone's interested in this history pre-1982, which I'm only briefly gesturing at, there's quite a nice book by Mary Janigan that talks about, why in the first place do we have equalization and where did that come from? So if you're curious, feel free to take a look at that. Okay, so there's 2 big pieces of 36 I want to focus on. The first one I'm going to call, for the purposes of our conversation, the equalization clause. So Parliament and the Government of Canada are committed to the principle of making equalization payments to ensure that provincial governments have sufficient revenues to provide reasonably comparable levels of public services at reasonably comparable levels of taxation. So what is this equalization business all about? Speaking very broadly, the federal government collects federal taxes all across the country. Many federal taxpayers in Alberta and in every other province, they're sending money to the federal government, and it's a big pot. And the federal government then distributes that money in such a way as to enable poorer provinces, to speak more crudely about it, to deliver comparable services. And this is why New Brunswick and Manitoba and PEI can have decent hospitals and schools. It would be easy for Alberta to do so based on its economic capacity, but it would be much, much harder for these other provinces. And so the federal government is distributing money all across the country. Here's a map of our country. I think we're all, except for me, in Alberta today. And I just want to make sure, Richard, is that little thing blocking any of the text that I see on the bottom? I think it might be the little bar with audio. It's okay if it is. But okay,
You're all good.
I'm all good. Okay, I'm just gonna close that. Okay, so if you're curious, I wanted to show you on this slide, how much of provincial and territorial budgets come from equalization. And it's maybe more than you think. And at the bottom, I hope it's not hidden, as you may know, in the last fiscal year, Alberta got nothing, redistributed back to them. Saskatchewan got nothing. BC got nothing. This is one of the reasons why Albertans are not always the biggest fans of equalization. But if you look to the other parts of the country, it's quite a huge part of provincial and territorial budgets. And I said that I wouldn't go deep into the history of equalization, but I just want to gesture at the three kind of animating purposes as I see them, as they were articulated back when this provision and this program was developed. And the three big reasons are, first, ensure the survival of smaller provinces, including PEI, Nova Scotia, and New Brunswick, because without equalization, they would either have terrible public services, which would lead to an exodus of people, or to deliver decent services, they would have to have crippling high levels of provincial tax, which in its own way would, send people away and to an exodus of people. The second big purpose, as Trudeau, the senior, and other negotiators discussed it, was just a recognition that we're interdependent. If everyone in Nova Scotia, New Brunswick, and Manitoba is getting a terrible high school education, people move around the country, and that would be an externality on the rest of us. So the fact that we are interdependent makes it in our interest for basic health and education and the like services to be decent. And this third idea was to have something that bound us together, something that bound Albertans and people in the East and in the North and the West. And this idea was, as Trudeau once put it, was to ensure the provision to every citizen, wherever he or she lives, though he didn't talk about the she's, of adequate levels of public services, in particular of health, welfare, and education services. So for all of us to share something. And when you think of it, it's actually quite an amazing thing that we have managed to share all this time in a way that ensures that so many of people in this country who aren't lucky enough to live in Alberta can still finance decent hospitals and schools. Okay, I want to note something, which is that if you read this carefully, you'll see that it mentions a commitment to equalization payments to provincial governments. It doesn't say anything about territories. And so immediately after this constitution was passed, Parliament decided to pass a statute which extended equalization to territories. And that is why we are sharing so much with the Yukon and the Northwest Territories and Nunavut, which could not function without this program. Now, and this is the first punchline of my talk, here's a map of Indian reserves all across this country. There's many hundreds of them, many of which are in Alberta, those little red dots, and over 300,000 people live on these reserves. That's more than the population of PEI. It's more than the population of all the territories. And these reserves, these red dots, are excluded from the equalization program. The equalization program literally ends at the borders of these reserves. There is no legal duty or constitutional duty of any kind to deliver comparable services to reserves. And I submit to you that one of the reasons, and there are other reasons, political and social reasons, one of the reasons why schools are so bad in the reserves all around you is because there's no legal commitment to comparable services. And I think this is a problem in the architecture of the country itself. You know, there's 37 million of us, and for 36.7 million of us, we have this legal safety net that these places don't, and that's not okay. In the case of this provision, I think there's very little legal work it can do in a court because the text is so plain that it doesn't apply to reserves. And so I point this out to you because I think it shows there's a political problem in the same way that it was a problem that territories were excluded. We have to kind of face up the fact that we have excluded reserves from equalization. And that bothers me. And when you see it, I think it's hard maybe to not let it bother you. I'm going to move on to the other part of Section 36 because I think this is where, as a litigator, as a judge, as a law student thinking about legal arguments in court, this is where the action is. And I think this is why this provision, I think, is important to a lot of cases today and future cases. Okay, so I'm going to call this the quality clause. And you'll notice that I chopped out some of the words, and it's just so we can make it a little bit easier to walk through. All right, so there's a commitment from Parliament and the provincial legislatures and their governments to, quote, providing essential public services of reasonable quality to all Canadians. What does that mean? The view of almost everyone until today, including from Peter Hogg, who wrote a textbook that I suspect a lot of you still use, was that this is just kind of empty aspirational language like a preamble. And so I'm showing you this arrow to kind of show you this range of how seriously these words we should take them. And the preamble is kind of fluffy stuff that we don't use in litigation, aspirational. And then on the other far end of the scale, there's an enforceable right, you know, like freedom of religion. You know that you can go to court and enforce that. And I think some of this current litigation that I've talked about is trying to convince judges that Section 36(1), this quality clause, is an enforceable right. I think that's going to be a pretty tough sell. It's outside of the Charter of Rights. It could happen, but I'm not totally persuaded that a court is going to go from that. What I am trying to argue is that it's something in between. It's not empty, meaningless language, which I think a lot of people have assumed, which is why people haven't used it in court and as we talk about public services issues. I use this language that is much more common in other jurisdictions, including Ireland and India, and actually, you know, many dozens of jurisdictions. If in comparative con law, it's something called a directive principle. And really what I mean by that is, and what courts and other constitutional systems mean by that is, it's words that we can use, among other things, to interpret other parts of our Constitution. And up till now, there's this, you know, a few cases, a handful of cases, you know, in Manitoba and in the east of this country have considered what Section 36 might mean. And like I said before, there's never been a ruling on what it means, but it's come up a few times. And to the extent that courts have talked about it, it's been to ask the question, you know, is this justiciable? And to use the words I just used a moment ago, is this an enforceable right? Is the sense in which these courts have often been asking this question. Does the infringement of this particular language give you a right of action to go to court? And what I'm trying to say in this paper is it may in itself give you a cause of action, or it may not. I don't think that's a big deal. I think it's a red herring, and that's been all the debate. I think it would be enough for us to say that this is a kind of principle that we can use as an interpretive aid. And I think the payoff for seeing it that way is to say, maybe it doesn't give you a cause of action in itself, Section 36. Maybe you can't go to court as a Canadian saying, my Section 36 rights were infringed, but you could say that I want to use that language to help us interpret what other parts of the Constitution and other obligations mean in the context of a dispute. So, for example, you might say, my Section 15 equality rights were infringed, and I think this Section 36 language in this case helps us define what those rights mean. I think I can envision cases that I kind of lay out a bit in the paper where there's treaty rights, like rights to schools and things like that all over Alberta, and you can combine it with this Section 36 language to kind of flush out what those treaty rights mean. Some of you may have followed, the development of honor of the crown as an interpretive principle, mostly related to Section 35 in Aboriginal rights. I think there's ways to combine honor of the crown and Section 36. And there was a recent case that I start the paper with about unequal policing on a reserve in Quebec, and that was based in contractual interpretation. And I think in a case like that, you could have a contract and you could have an honor of the crown principle, and you can have Section 36. And I think it really sharpens the argument of someone who's saying these unequal services on reserves, which is the thing I'm particularly interested in this paper, is a constitutional problem for us in a way that's been hard for litigants to say in the past. So, and we're waiting for this to happen. I cite in the paper some facta that have invoked Section 36 in a way that I'm not sure is going to work, but I'm quite certain that on appeal, this, we're going to see first of all, in decisions coming out this year or next year, Section 36 decisions, which we haven't seen for the better part of a decade or two, we're going to see a couple. And then on appeal, we're going to have quite a live debate about, what this Section 36 business is all about. So I'm conscious of time passing, and I'm just going to show you my last slide so we have time to talk. So this was my takeaway. Whether or not these clauses are justiciable, I think they can still help us interpret other things. I just want to gesture at these objections. I'm going to describe the objection, and so that we can get to questions and comments, I'm not going to rebut them for now, unless you want me to. But I think I can deal with all of them one by one. The objections I just want to note to show you that I see them are, the end of the equalization language, you may recall, talks about reasonably comparable levels of public services at reasonably comparable levels of taxation. You might read that and say, well, on Indian reserves, there are less types of certain taxes. I think we often overstate the less taxes thing, but in some cases it is real. And so you might say, oh, maybe that's a reason at a legal level for it to be permissible to have worse services. And I don't think that argument holds that much weight for reasons we could talk about. You might say that on Indian reserves, comparability, which is what this language, this principle, I think can get us towards. Pardon me, I'm skipping to number 3. Comparability may not actually be what Indigenous communities want. They may not want comparable schools. They may want to have different schools. They may not want comparable policing. They may want to do policing totally differently. And I think there's a way to address that. I want to go back to number 2, and this is an important one. which is, if you're a federal lawyer or someone who's very familiar with federal policy, you might say, okay, we don't have a statute or a constitutional duty to deliver comparable services for these 300,000 people, but our policies do say we should often aim for that. And that would be true. There's education policy guidance that says we should, we're endeavoring to deliver comparable quality secondary school, for example. And this one, I just want to address for a moment to say the problem with this, and we see this in active litigation today, when people try to enforce that policy, the government says, oh, we have discretion over that. We can do that or not do that. That's just a policy aspiration. There's no legal duty. So when push comes to shove, I don't think that's good enough. The fourth objection I just want to mention is that I haven't quite nailed down the scope of essential. And by essential, I mean essential public services. What are we talking about that? I tend to think it's much wider than essential in the emergency law context. Uh, as I kind of gestured at before, I think it does certainly include social services and education, but I think there's some room for debate there. I want to say that the biggest problem for a judge is going to be that these cases involve a lot of money. And as I suspect you all know, uh, judges don't really like saying in their remedies that a government has to spend many billions of dollars. There's principles of judicial restraint. There's some case law that spells out quite clearly that judges should be reluctant, at the very least, to tell Parliament and provincial legislatures to spend huge amounts of money as part of their remedies. And I think that there's ways to recognize that concern and still think that there's a lot of space for courts to make declarations and to have creative remedies that require parties to negotiate to kind of deal with that. And I could not complete this overview of objections without noting that if you're familiar with this problem of unequal services on reserve, one of the controversies is the fact that the services are worse, which is kind of my focus. But the other big controversy is who delivers that service? Is it the federal government? Is it the provincial government? Is it an indigenous order of government? Is it municipal governments? And that is an essential part of this policy problem. And I think Section 36 has nothing helpful to say about that. So we have to not expect Section 36 to address that knotty problem. So I'm going to stop there, and I'm happy to detain myself further on these objections, but I want to give everyone the chance to opine or question or critique. And if I went through too quickly anything, I'm more than happy to go back. So I'd be happy to open it up.